Are foreign wills recognized in Vietnam? It is one of the most common questions raised by expats and foreign investors who own assets in Vietnam. Unfortunately, it is often asked only after a death has already occurred. Vietnamese law does not automatically reject foreign wills, but it does not automatically enforce them either. Recognition depends on multiple legal factors. When assets are located in Vietnam, Vietnamese inheritance law becomes central. Vietnamese courts and notarial authorities assess validity under domestic legal principles. Foreign documents must pass through this framework. The first issue is formal validity. Was the will legally executed under the law of the country where it was signed? Was it properly witnessed, notarized, or certified according to that jurisdiction? Vietnamese authorities will examine this carefully. A foreign will cannot simply be presented in Vietnam. It typically requires consular legalization or apostille, depending on treaty status. Without proper legalization, the document may not be accepted for probate in Vietnam. All foreign wills must be translated into Vietnamese by a certified translator. Accuracy is critical. Ambiguity in translation can alter interpretation and trigger disputes. Even if a foreign will is formally valid, its content must not violate mandatory provisions of Vietnamese inheritance law. Vietnam recognizes the concept of forced heirship for certain dependents. A law that entirely excludes protected heirs may face challenges. Vietnamese law protects specific categories of heirs, including minor children and certain dependent family members. These individuals may be entitled to a compulsory share of the estate. A foreign will cannot simply override these statutory protections. For immovable property located in Vietnam, Vietnamese law almost always governs inheritance issues. Foreign law rarely overrides local real estate succession rules. This is particularly important for expats owning apartments or land use rights. For movable assets such as bank accounts or shares, conflict of law analysis becomes more nuanced. Nationality, domicile, and asset location all play a role. Each case requires structured legal assessment. Recognition of a foreign will does not eliminate Vietnamese probate procedure. Heirs must still complete local notarization or court confirmation processes. Without this step, assets cannot be transferred legally. Many foreign clients believe that a single will drafted abroad covers all assets worldwide. In practice, this assumption often creates delays in Vietnam. Procedural barriers can freeze assets for months or years. Foreign families sometimes present a foreign probate order expecting automatic effect. Vietnamese authorities may require separate local recognition. International enforceability is never automatic. Foreign wills that are clearly drafted, properly legalized, and consistent with Vietnamese mandatory rules stand a stronger chance. Clarity and compliance significantly improve outcomes. Ambiguity invites litigation. For expats and foreign investors with substantial assets in Vietnam, a separate Vietnamese will is often advisable. This does not replace a foreign will, it complements it. However, dual wills must be coordinated carefully. Contradictory clauses can create cross-border disputes. Strategic drafting is essential. Inheritance in Vietnam may also involve tax reporting obligations. Foreign heirs must comply with local procedures before asset transfer. Delays often arise from incomplete documentation. Inheritance disputes involving foreign elements are increasing in Vietnam. Mixed nationality families and overseas heirs complicate proceedings. Preventive estate planning reduces exposure. If you own assets in Vietnam and have drafted a will abroad, do not assume automatic recognition. Review your estate structure proactively. Legal coordination across jurisdictions is not optional. Foreign wills can be recognized in Vietnam, but recognition depends on compliance, localization and alignment with Vietnamese inheritance law. For cross-border families, clarity before death is far less costly than litigation after it. If you are an expat or foreign investor holding assets in Vietnam, do not assume your foreign will function exactly as intended. Recognition under Vietnamese law is possible, but only with proper structure, localization, and coordination. To review your estate plan and assess whether your foreign will is enforceable in Vietnam, contact LTS Law at lts.com.vn for professional legal guidance.